For the County of Sheboygan, and we are providing public access on our civil docket, both in the courtroom and also online. And up next, we have a motion in the matter of Moran v. Bishop, file 24-9092NZ. Counsel, you want to state your appearances, beginning with plaintiff?
Good afternoon, Your Honor. Sandy Jasinski, appearing on behalf of plaintiffs Thomas Moran and Moran Iron Works.
Okay, good afternoon.
Good afternoon, Your Honor. Adam Flory, Smith Boville, PC, appearing on behalf of the defendants.
All right, good afternoon, Mr. Flory. All right, this is a motion for sanctions for alleged spoliation of evidence or, in the alternative, failure to comply with a discovery order. I have had an opportunity to.
This case may look like a routine
might appear to be a routine dispute over discovery.
What you're about to hear is a courtroom autopsy of credibility,
deep examination of credibility, intent, and responsibility inside the courtroom. At the heart of the conflict is a radio host
making
accused of using his broadcast platform to make explosive accusations, then allegedly erasing the digital evidence once legal pressure started building.
A business owner fighting to
stands a
protect his
business owner
reputation
determined to defend his reputation after being publicly accused of committing a federal crime.
This isn't just about missing
This conflict goes far beyond missing text messages.
It
raises a bigger question about when the obligation to preserve evidence actually begins. It also examines how courts respond when parties treat discovery rules casually, and whether claiming "I delete everything" functions as a defense or an admission. Pay attention, because the judge already seems frustrated, not only with what evidence may have been erased, but also with how the defendants have behaved during the litigation process. Here's the interesting twist. Liability has already been determined. The only remaining issue is damages, which means intent, credibility, and missing evidence now carry even greater importance. As you watch the case unfold, consider this question. If someone tells their audience they received texts supporting their claims, but those messages later disappear, what conclusions should a jury be allowed to draw? Stay with us, because this ruling could have consequences that extend well beyond this courtroom.
Brief in support to the exhibits and the motion in brief in opposition, the response in brief in opposition to the motion. Ms. Jasinski, you want to go ahead and argue the motion?
Yes, Your Honor, thank you. As a preliminary matter, I would note that I was somewhat surprised by I believe it is footnote 2 in Mr. Flory's response, where he commented that he had not had it because of his client's limited means, and we can certainly debate that, but because of his client's limited means, he hadn't had an opportunity to obtain the deposition transcripts of Mr. and Mrs. Bishop. Those were attached as exhibits to the motion, Your Honor, as Exhibit 7 and Exhibit 8. So Mr. Flory actually has had copies of those transcripts. They were provided in their entirety, not only to this court, but they were emailed to Mr. Flory and mailed to him as well.
Well, I guess he owes you a little bit of thanks then, since you got him for no fee.
Full service, Your Honor, full service,
right.
Absolutely. Ironically, Your Honor, today is the 16-month anniversary of when defendants decided they wanted to play stupid games. On that date, Mr. Bishop falsely accused Tom Moran and Moran Iron Works of flying in illegals to work at Moran Iron Works, the metal fabrication company that he founded and owns and operates in Onaway, Michigan. Those accusations are false. They accused Ms. Moran and Moran Iron Works of violating a federal statute regarding hiring people who are not naturalized citizens or citizens of the company without complying with federal law. They essentially, Mr. Bishop accused Mr. Moran and Moran Iron Works of a felony. And indeed, in the transcripts that we've provided to the court previously, not only on September 12 did he falsely accuse with malice and recklessly Mr. Moran and Moran Iron Works of violating federal law. He also urged the local law enforcement officer, the sheriff in Presque Isle County, to arrest Mr. Moran as a result of that. These statements were broadcast on WCHY, which is a station that is owned by Mrs. Bishop, Mr. Bishop's wife. There was a letter that was sent on September 20 to Mr. Bishop demanding a retraction and giving him until the 30th to retract and advising if that wasn't done, that he would be sued. There was silence in response to that letter. But Mr. Bishop couldn't restrain himself, nor has he been able to restrain himself from shooting his mouth off about Tom Moran and Moran Iron Works since September 12th. On October 4, a retraction letter was sent to WCHY, and Michigan Broadcasters, the LLC that is owned, again, the sole member of which is Mrs. Bishop. As we noted in the motion that we filed, according to her deposition testimony, Mrs. Bishop apparently appears to be a member on paper only, and the operation of the stations are her husband's. He is the station manager. She never looks at the email. She claims in her deposition she never saw the demand for retraction. Nevertheless, that demand for retraction did prompt some action on the part of Mr. Bishop, who decided that he would, on October 7th, try to make a retraction. Those broadcasts, Your Honor, on the 12th, there was one on the 25th, and certainly on November 4, those broadcasts and the transcriptions of them are the subject of requests for admissions that were sent to defendants in terms of having them acknowledge that those are authentic transcripts, that those words were said. And the court may recall that on October 13th, they're playing fast and loose, and the responses to the request for admissions were deemed by this court, defendants' responses were deemed by this court to be inadequate, and they were deemed to have admitted the truth and authenticity of those statements. On November 5, litigation hold and preservation letter was sent to Mr. Bishop, and arguably, Your Honor, that's belt and suspenders.
Sure. So that gets to, like, some of the text messages appear to have been,
This moment represents a key legal turning point, and it's where many people, even experienced litigants, make mistakes. Spoliation is not limited to destroying evidence after a lawsuit has officially begun. The obligation to preserve evidence begins when a person knows or reasonably should expect that legal action is likely. In this case, the judge focuses on the September 20th retraction letter because it clearly warned that a lawsuit would follow if a retraction was not issued. That detail is important. From that moment forward, deleting potentially relevant information is no longer neutral behavior. It becomes legally risky. Notice what the plaintiff is arguing here. They aren't claiming that every deleted message matters. Instead, they point out that the defendant repeatedly referenced text messages during his broadcast that supposedly supported his defamatory claims. Once you publicly rely on evidence to support your statements, that evidence becomes subject to discovery. That leads to a simple but powerful question. If those texts existed when they supported the defendant's narrative, but now cannot be produced when the court requests them, what happened to them? And even more importantly, who should face the consequences of that missing evidence?
if we take Mr. Bishop's testimony at its face value, would have been deleted prior to the hold letter. But as I understand the law of spoliation, the obligation to preserve may have arisen prior to that.
Absolutely.
Do you want to articulate when you think the obligation to preserve arose in this case, and whether that obligation extends to the corporate defendant to the extent that they can be held liable for the individual defendant's spoliation?
I would argue that the obligation apart from the case law, the obligation first arose when the letter for retraction was sent to Mr. Bishop on the 20th, because it said litigation will ensue if an appropriate retraction is not made. In terms of the obligation of the corporation, Mrs. Bishop made it clear in her own testimony that, hey, I don't look at the company's email. Mr. Bishop does that. That's what he does. And the other thing, Your Honor, to keep in mind is that we have testimony in the bankruptcy court litigation, and those transcripts have been previously provided to this court in the context of other motions. What the cell phone that Mr. Bishop uses in connection with his life, both personally and professionally, has to be paid for by the company, because Mr. Bishop testified that his sole source of income are Social Security benefits that he has been receiving, and he uses those funds to buy gas for his vehicles and basically, snacks at gas stations or meals at gas stations when he's driving around. Records that we also have from Michigan Broadcaster shows that they are paying for Mr. Bishop's cell phone. So the company has delegated, through Mrs. Bishop, has delegated responsibility for the company's operations to Mr. Bishop. They pay for Mr. Bishop's cell phone. They are responsible, and they were specifically sent a letter stating that demanding a retraction, which certainly would have put them on notice by that day. But before then, I would submit, Your Honor, and based on testimony that we've derived so far, it's not an issue for the court right now, but it's going to be. That corporate veil of Michigan broadcasters will ultimately be pierced. It's the alter ego of Randy Bishop. Now, in any event, Mr. Bishop testifies, well, I just routinely, at the end of every day, I just delete all my text messages. And he was doing so even after having received the retraction letter. And there are exhibits, or there are requests for admissions that reflect transcripts of particular broadcasts that he specifically refers to text messages that he has been receiving from listeners in response to the Moran lawsuit. And again, Your Honor, he can't shut up about it. As at the last hearing on October 13th, one of the items that I wanted to provide to the court, and the court wasn't really interested in it at that time, and I understand that, were postings and face sheets for a Give, Send, Go campaign that Mrs. Bishop began to raise monies for a legal defense. She started that in April 24, 2025. The goal was to raise initially $25,000, and there are a number of acknowledgments that were made. Thank you so much for contributions. The last I saw, I think they lowered the demand to $10,000. But Mr. Bishop, during his broadcasts, and there are a number of them that we have identified, certainly not all of them, but at one point in September and October, Mr. Bishop at one point said, I'm literally going to be asking you every day to contribute to this legal defense fund. Text me and I'll give you the information. He was congratulating on air or referring on air to text messages that he had received that he deleted, and certainly after September 20 of 2024. And the other thing, Your Honor, and it's not only the text messages that we're talking about here. When you look at what the request for production was, and it's submitted to the court, the request for production refers to all communications with audience members. And if I'm fumbling around here, Your Honor, looking for that particular document.
Well, but how would that be? I mean, we have the courts all.
This exchange is extremely important because it shows why missing evidence still matters, even though liability has already been established. The jury is no longer deciding whether defamation occurred. Instead, they must determine the severity of the wrongdoing. Intent, recklessness, and motive all play a direct role in calculating damages, especially when exemplary damages are being considered. If the defendant claims he relied on tips from listeners, the jury has a right to know whether those tips were reliable or whether they existed at all. Without access to the alleged text messages, the plaintiff loses the opportunity to challenge that explanation. Courts generally refuse to allow one side to gain an advantage by destroying evidence that could reveal the truth. That's the purpose of spoliation remedies. They are not meant to punish, but to restore fairness between both parties. And the judge's comments here make it clear she is thinking carefully about maintaining that balance.
Already ruled by default as to liability
Yes.
and we're at damages. So I understand. Tell me if I'm understanding your argument right about why these texts are relevant to the exemplary damages. Because Mr. Bishop is saying on a broadcast, I've got people texting me this information.
Mm-hmm.
Therefore, he may argue to a jury that, I'm just repeating what somebody showed, so that therefore, his intent in doing that would be relevant even as to the measure of damages. And you're entitled to find out, is he lying when he says he has those text messages? Or if he's telling the truth, are they from a source that should reasonably have been considered reliable or not? Am I understanding that right?
That is correct, Your Honor.
All right. So, but communications he would have with audience members about, contributing to his legal defense, although the deletion of those texts would be a violation, the remedy's got to be pretty carefully drawn. How would those texts be relevant to any issue to be tried?
Because what Mr. Bishop also said in those on-air statements was, text me the information, or text me, I'll send you a link and give you the facts. So what he was doing would be continuing. We don't know, for example, what facts that he was sharing with that particular audience member.
Continuing to make defamatory statements.
Continuing to make defamatory statements.
Okay.
Continuing to make defamatory statements. Exactly.
That helps me understand.
Okay. In terms of the request for production, Your Honor, actually, when you look at request for production number 1, from September 1, 2024 through the present, all communications between Defendant Michigan Broadcasters LLC, Defendant Bishop, and purported audience members of your defending fathers, including but not limited to text messages sent to either defendant regarding Thomas Moran. Now, as I noted, Your Honor, there are examples, even after the litigation, that we provided in the context of the request to admit, where it is clear that after the institution of the lawsuit, it is clear that after the litigation hold letters were sent out, that Mr. Bishop was, again, shooting his mouth off about Tom Moran, and those were being broadcast over the airwaves of WCHY. He doesn't identify any of the broadcasts, and we know from what he stated, I believe it was in September and October, that there was at least one broadcast where he stated that I am going to be, seeking money. You're sending me, it's talking about this lawsuit every day. If I don't get the money for my legal defense fund, we're going to have to go off the air. What did he receive? What did he receive? At one point in September, he refers to two $500 money orders that had been sent to him by some guy in the text exchange that they had, and he's so grateful about it. What did he receive, and what did he say? Was it additional defamation that he was providing? So we have no text messages. We have no identification of the broadcast referring to Thomas Moran. We do know of one that was, frankly, loads of fun for me, Your Honor, being referred to as an evildoer. And I had to remind counsel that there are 3 attorneys in the state of Michigan with the last name of Jasinski. One of them is Kathy Jasinski, who I've met once in my life. We get confused all the time. We graduated from law school at about the same time. If you were to Google pictures of us, we kind of look the same. And I had to be very clear with opposing counsel. Please, if you're going to make reference to the evildoer Jasinski, make sure it's Sandy Jasinski and not Kathy Jasinski, because I want to get all the glory for being called an evildoer by trucker Randy Bishop. So we have, it's been an ongoing situation in this court and in bankruptcy court, and we've provided the court with that evidence. Defendants in this case don't believe the court rules apply to them. They don't believe that court orders, whether it is issued by a bankruptcy court or by this court, apply to them. They play by their own rules. We are not required to accept Randy Bishop's word that, oh, gee, I just routinely delete these messages because none of them have anything to do with Tom Moran. The request for admissions and their responses themselves, without having to go through and dig through all of his other broadcasts, which are archived. Those documents show that Mr. Bishop has received texts. He did receive texts. He did receive the litigation hold letter. He certainly received the retraction letter, and he and his wife did absolutely nothing to preserve evidence. This, Your Honor, and this court is not their first rodeo with the judicial system. Putting aside for a moment that they share, 3 divorce lawsuits between them before they got married, Mr. Bishop has gone through 2 bankruptcy filings. There are election law claims that they have filed, and there are multiple lawsuits that were filed against Mr. Bishop and his wife for unpaid debts.
Right.
They know how the system works.
That's a
They know
little
what their
far
obligation
afield.
is to preserve evidence. They didn't.
Can I ask you a question about remedy? As I look at the model civil and jury instructions for failing to produce evidence, might or might not particularly fit. It seems to me, though, if I were to rule in your favor that the defendants did fail to preserve evidence with no reasonable excuse and that is relevant to you, number one, that would be limited to any text messages on or after September 20th with the whole
Correct.
letter. But also then, if we actually get to, which hopefully we will soon, to a trial, that then there'd have to be something laid out specifically by you in terms of a requested special instruction to tell the jury the defendants failed to produce the text messages they referred to in the broadcast on X and such date. That you may infer, or that I would instruct them, there is no reasonable basis that they have failed to produce those text messages. You may infer that they are adverse to them.
You may infer that they're adverse or that they simply don't exist and he was
Yes,
lying.
Yes.
And he was lying.
Right, which is why the model instruction may not fit. But you'll have to identify at some point, like precisely which text messages and which broadcasts you're talking about, right?
And therein lies the rub, because the first request for production of documents said all communications to audience members, which means they're broadcasts. Your Honor, again, we have occasionally there's information that we receive that we might want to listen to a broadcast on a particular date. So for example, there are broadcasts that Mr. Bishop in September and October where he was pleading for funds and text me if you need the information and I'll give you the facts. He broadcasts 3 hours a day, Monday through Friday. And the amount of time that would be necessary for the plaintiff to go through all of those broadcasts and identify each one is mind-blowing. It's their obligation because we asked for it. Certainly, they cannot take the position by just focusing on text messages. First, they want you to accept that, oh, there are no text messages. Well, we know that's wrong just from the text messages we did find, because he refers to them all the time. And if you listen to Mr. Bishop's program for any amount of time, and unfortunately I have done so, if you listen to it for any amount of time, he is constantly referring to, I'm getting a text from Gary, or I'm getting a text from so-and-so about this. And in fact, Your Honor, in this case, in the Maria case, when he's talking about the defamatory statement that's on September 12th, he refers to a particular listener by name.
Right. So it seems like the most that I would be able to do today would be to rule that the defendants did improperly spoliate evidence.
Yes.
And that then you are entitled to a remedy, and that whether the remedy includes your attorney fees, but beside that even if I were to rule that you're entitled to an adverse jury instruction, the precise wording and parameters of that jury instruction would be left for a later day.
I think you are right, Your Honor. I would agree with you on that.
Okay, so that when it gets time to submitting jury instructions, I would have ruled that you're entitled to a spoliation jury instruction. You would submit a special jury instruction. Mr. Flory could submit one that he thinks comports with the court's ruling, but is a better example, or he could object to it, and we'd have to sort that out. Is that right?
Correct.
All right. What about your request for fees for this? What are you pressing about that?
It's seriously, Your Honor, we've had to, it's been such a battle in terms of discovery here. It has been a battle to get a proper answer to the original complaint that was filed. It is a battle to get these folks to be deposed. It is a battle to get them to answer any kind of discovery request, and they still haven't fully answered the discovery request here. Identify the broadcast. They have not done that. So we would ask that we, for a an order that we are entitled to the attorney's fees that are generated in connection with this spoliation motion and an amount to be taxed, and that would include my attendance here at the hearing today.
So then procedurally, if I were to grant that relief, and I haven't heard from Mr. Flory yet, but if I were to grant that relief, it would be saying you're entitled to that relief, then you would submit a bill of costs to Mr. Flory. He would have an opportunity to object either to the amount of the hours or the amount of the hourly rate.
Correct.
And if he does, then we would have a hearing.
That's exactly what happened in bankruptcy court when Mrs. Bishop was held in contempt for violating that court's order. So yes, that's what I would envision the process would be.
All right, thank you. Anything that I need to know more to understand your argument?
No, Your Honor. I will ask any or answer any questions you have after Mr. Flory's presentation, but that's the relief that we're seeking. Thank
All
you.
right, thank you. Mr. Flory, your response, sir?
Thank you, Your Honor. Your Honor, initially I would note that I'm going to circumscribe my presentation to a much higher degree than did Ms. Jasinski. A significant amount of what was just veered to the court was completely irrelevant to this motion. Ms. Jasinski talked about litigation my clients had been in decades ago. She talked about things that happened months ago in this litigation. It's just entirely irrelevant. So, Your Honor, I'll just state we don't agree with it. We vehemently disagree with much of what was stated, but I'm not going to go beyond that, Your Honor, because I don't think it's relevant. Your Honor, as to this motion, we have fully complied with the discovery request. Ms. Jasinski had talked to me about filing a motion to compel, and then she dropped that motion in favor of this motion. And so I have no idea what she's talking about when she says we haven't complied with the discovery request. We certainly have. We've complied with this court order. Your Honor, initially, Ms. Jasinski talked about filing a motion to compel relating to text messages. I don't have any text messages to give her, Your Honor. I don't have.
Sure. So that's why I understand that to be sort of in the alternative. She's saying either your client destroyed these text messages or they have failed to produce them. And so you've said, and your client has said, we don't have them. So that's why it's not a motion to compel their production. So I understood her argument about that to be sort of either in the alternative or some amount of rhetorical flourish there. But really what we're talking about is an allegation that your client, despite the hold letter, continued to delete text messages he received during these broadcasts. And do you agree that that's factually true? I mean, his deposition testimony admitted as much, right?
Yes, Your Honor, but I think the salient point and the important point is that my client's not precluded from deleting text messages. My client is precluded from deleting text messages that relate to this, that could be relevant in this litigation. That's, you know, if he gets a text message regarding some vote that occurred in the Federal House of Representatives, that's not relating to this litigation, and that has no connection here, so he can delete those. And so, Your Honor, that's essentially the bottom line. So, and if I may, I was talking about the discovery and the answers to discovery and the motion to compel that Ms. Jasinski and I had discussed, also in the context of the allegation that we've not complied with discovery, which is untrue. We've completely complied with discovery, Your Honor, and this court's order. With regard to the spoliation, Your Honor, I think we all agree that the law is that when a party knows or reasonably should know that litigation is forthcoming, they are under an obligation to preserve evidence that could be relevant to litigation. That's the basic black letter law relating to spoliation. So in this case, Your Honor, again, for the record, I would also say, unfortunately, I received the email on this motion 8 days ago. I could not open the transcripts. They were saved and they were not PDFs. They were some kind of unusual file extension. So I could not open those attachments for the transcripts, and the mailing has not arrived at my office yet. So I did not have the virtue of having those transcripts, although I do appreciate Ms. Jasinski sending them. So having said that, Your Honor, that's why, unfortunately, I can't point the court to the specific page number, but especially during my redirect, so to speak, of Mr. Bishop towards the end of the deposition, he makes clear that none of the messages that were deleted related to this lawsuit, related to Mr. Moran, related to the alleged.
Well, but that can't possibly be true. I mean, he at the same deposition, and it's quoted on page 6 of Ms. Jasinski's brief, where on an October 7th broadcast, which was after the retraction letter was issued. He says, I got a couple text messages from witnesses that I would call to defend my statements on September 12th and September 25th. I'm not going to name names because I may have to put you on a witness list and have you give a deposition or perhaps testify in a courtroom. And then he's deleted those text messages. That seems like classic spoliation, doesn't it?
Your Honor, what I would say is I don't know the veracity of the statement.
Here, the defense faces a delicate balancing act. Their argument is that statements made during a radio broadcast should not outweigh sworn testimony given under oath. In isolation, that idea has merit. However, credibility is never evaluated in isolation. Courts compare different statements, particularly when a party benefits from one version of events and later attempts to distance themselves from it. Saying, I never had those texts under oath does not automatically erase earlier claims that those messages existed, especially when those earlier claims were used to justify harmful public accusations. The judge appears skeptical of the argument that a sworn denial alone resolves the issue. That isn't how fact-finding works in court. What we are seeing here is the court carefully analyzing intent and considering whether the overall pattern of behavior suggests an attempt to prevent the other side from accessing important evidence.
Statements he made on the radio. So what I know is
I think I finally found a point in which you and Mr. Jasinski agree.
so
How about that? That
I
you both
agree.
just agreed that Mr. Bishop lies on the radio. How about
Well,
that?
I'm not saying that, Your Honor. I'm not saying that, but
Well, if what he said was true, that's spoliation, right?
I think it would depend upon the nature of the messages, Your Honor. But what I would say is I don't know the veracity of what Mr. Bishop says on the radio. What I know is that in his under oath testimony given at his deposition, he stated that he does not have any text messages that were relevant, and he never did. So, Your Honor, with respect, Mr. Bishop's not. It's not a crime. It's not a tort or a civil wrong to use hyperbole on the radio. It's generally not even a crime to lie on the radio. It's simply not, depending on the context. Obviously, there are circumstances where it could be, but to say I got text messages when you never did, that's not a wrong. And so, and again, Your Honor, I'm not saying that's what happened. I'm saying I don't know about the veracity of those radio claims. What I know for sure is that in the under oath testimony from Mr. Bishop, he says, I never deleted any text messages that relates to this lawsuit, Mr. Moran Ironworks, the alleged defamation, none of that, Your Honor. And Ms. Jasinski's not pointed to any statements under oath that would contradict that. So
at the trial on damages, which is, I guess, the only issue remaining. These broadcasts are going to be played for a jury, and the jury's going to hear, I presume, statements from Mr. Bishop about, oh, I got some text messages from people that would support my statements. And then Ms. Jasinski, seems to me, is at a disadvantage because she can't explore whether that's true or false, whether they were reliable and should have been relied on by Mr. Bishop. And that goes to his intent and a proper measure of damages. So isn't she entitled to an instruction of the jury that, gee, we don't have these text messages that Mr. Bishop referred to. So either, as you suggested, he maybe was lying and didn't receive such text messages, or if he did, you're entitled to conclude that they would be adverse to his interest because he has failed to produce them. Wouldn't that sort of put her in equal footing? I mean, to deny her motion seems to be to put her at a disadvantage because your client either destroyed evidence or is lying about evidence or is lying about the existence of possibly exculpatory evidence.
well, Your Honor, respectfully, I would disagree respectfully. Ms. Jasinski had an opportunity to address this and explore this, and that was at my client's deposition. So she's had the opportunity to determine and ask my client specific questions about whether he was truthful in the radio broadcast that she had. She has every opportunity to go through that process, Your Honor. And Your Honor, I would also just like to know, this is, Your Honor, this is the one time where I'm going to be a little bit far afield. But I just want to note for the record, Ms. Jasinski stated it was difficult to get my client's depositions. I would disagree with that. Ms. Jasinski to this day has refused to produce Mr. Moran, and that's going to be the subject of a motion upcoming with this court, Your Honor. So it's actually the plaintiffs who have refused to provide that discovery and not the defendants. But in any event, Your Honor, I go back to the nuts and bolts of the motion. My client is being accused of spoliating evidence. My client's being accused of destroying evidence that was relevant in some way to this action. And my client did not do that. He never had these text messages. And so, Your Honor, my client's not liable for spoliation. I don't think Ms. Jasinski is on unequal footing with regard to the radio broadcast, because these folks who support my client's statements, allegedly, will either testify or they won't. I don't see how she loses anything there. She took Mr. Bishop's deposition. She engaged in discovery. She has every opportunity to find out who is going to be supporting Mr. Bishop's statements, and we've given her those names. We've given her every one of those names, both in writing and at the deposition, Your Honor. So I would again just return to the nuts and the bolts of the motion at bar, which is that my client is being accused of spoliating evidence, and there's simply no evidence that he did that. None. My client's uncontradicted statements under oath were that he never had any text messages that relate to Moran Ironworks, defamation, or this litigation. That was testimony uncontradicted under oath, Your Honor, and that's never been besmirched in any way. So, Your Honor, my client
other than when a litigant in any kind of litigation, whether it's civil or criminal or whatever, somebody has evidence that a person took some action, and then the person testifies under oath, well, no, I never did that thing. That's not just dispositive, right? I mean, he's got statements he made. I'm getting text messages, and I'm not going to say who they are because I don't want them to get dragged into court. And then he later testifies, I just kept deleting all the text messages I got. So it seems to me strange indeed to say all he's got to do is say under oath, nuh-uh, I didn't do that. And that's just dispositive. We just have to accept that.
I think it is dispositive, Your Honor, because the previous statement was not under oath. There's only one statement.
I guess all sorts of trials when the defendant stands up and says under oath, I didn't do it. We're just done for the day.
Your Honor, we're talking about the juxtaposition of two statements, one that was under oath and one that was not. I'm not saying that a party or a litigant's position must be taken wholesale under oath. I'm saying that when we're looking at the weight of two statements, one that was made under oath and one that was not made under oath, the statement that was made under oath should be given superior weight, Your Honor. I don't view that as.
I'll grant you that's generally true.
So, thank you, Your Honor. And again, Your Honor, I go back to the fact of what evidence is there that my client spoliated evidence. He's never, ever, under oath or in response to discovering this action, claimed to have these messages. He's consistently said he does not. So, Your Honor, there's no evidence here to suggest that he did destroy evidence. Thank you, Your Honor.
Thank you, Mr. Zinski and your vote.
The request for admissions, Your Honor, that the court has deemed admitted speak for themselves, as when you compare it against Mr. Bishop's sworn testimony. I will note too, Your Honor, that there are transcripts, and I believe they were attached to the request for admissions, where Mr. Bishop stated on the air, I've never lied in my life. Okay, great. He received a hold letter. He ignored the hold letter. He testified that he just goes through and deletes everything. At the end of the day, it's delete all, and that he doesn't look at anything. This is pretty much a textbook example of classic spoliation.
All right, thank you.
Thank you, Your Honor.
Well, in this case, the plaintiff is asking for remedy for spoliation of evidence on the part of the defendants. Here there was a hold letter issued, and even before that, a retraction letter issued for defamatory statements that were made on the air. The court has already ruled as to liability, and we're really just waiting to schedule this for trial as to damages. The defendants did have an obligation acknowledged by defense to preserve evidence even prior to the issuance of a hold letter. It's when they knew or should have known that the matter could be the subject of litigation. And the plaintiff's counsel has rather forthrightly admitted that that would not have arisen prior to September 20th when there was a retraction letter issued. But I think on September 20th, that obligation did arise. And I think the defense doesn't dispute that. They just dispute that there was any spoliation of evidence. Now, Mr. Bishop did testify that he, despite the retraction letter and despite the hold letter, despite that obligation, continued what he testified to be his standard practices of deleting every text message that he receives during his broadcasts at the conclusion of the broadcast. That would be a violation of that obligation. The defense says, well, but there's no indication that any of that was relevant to this case. And Mr. Bishop said under oath, none of it was relevant to this case. However, we also have his statements broadcast particularly as noted by plaintiff on October 7th, after the obligation to preserve evidence arose. Mr. Bishop is making public statements that he's received text messages from witnesses that he would call that would defend his defamatory statements. He says he's not going to give their names because he wants to avoid them being dragged into the lawsuit. And you combine that with his testimony that he deleted.
This is the moment when the ruling becomes clear. Intent is the key factor behind spoliation sanctions, and the judge identifies it within the defendant's own statements. The defendant publicly explained that he would not identify witnesses because he didn't want them dragged into court, while at the same time deleting the messages that could reveal who those witnesses were. That combination sends a strong signal. The judge is not relying on speculation. She is connecting the defendant's public statements with his private actions. Once intent is established, legal consequences follow. That is why this ruling carries such weight and why the defense's argument loses momentum at this stage.
Text messages he received. I think that is classic spoliation of evidence, and it shows, importantly, to receive a remedy for spoliation, you have to show some intent to deprive the other party of the evidence. And that's about as clear as you're going to get. A defendant's statement, I don't want the other side to have these names. I don't want the other side to have this information. That I think is the clearest statement of intent for spoliation that you could get. So, I mean, this is quite obviously spoliation of evidence. So I'm going to grant the motion and rule as follows: that the plaintiff is entitled to an adverse jury instruction on spoliation for any text messages referred to or received or sent on or after September 20th, 2024. Obviously, the precise parameters of that jury instruction are going to be subject to further refinement as Ms. Jasinski identifies which particular text messages we're going to be talking about at trial. I don't think you're entitled to just a jury instruction that they can just assume there are thousands of these things and he's destroyed them all. We have to identify what they are. And listen, I'm pretty reluctant to grant attorney fees, but I'm going to grant it in this case. This case has been like pulling teeth for the plaintiff. I've had strike pleadings that the defense has filed, and then they've filed barely better things. I've had to chastise defense counsel for making statements to this court that I think have fallen short of certain obligations I think he has. I've had to issue sanctions on request to admit for the defendant's bad faith or dilatory responses. This is just defendants who are just not, they're trying to make this litigation as absolutely difficult as they can for the plaintiffs, and now clearly destroying evidence. Plaintiff is entitled to attorney fees for anything that was expended in presenting this motion, including the time today. So, Ms. Jasinski, I'm going to ask you to submit an order, either stipulated as to form or under the notice of presentment. And that order should also say that 14 days after the entry of that order, you must file a bill of costs and serve Mr. Flory with it. Mr. Flory, within 14 days of that date, may file an objection to either the rate or the amount of hours for the reasonableness. If there's no objection filed, I'll enter an order to that effect. And because it's spoliation and not any actions of counsel, this will be payable not by counsel, but by defendants. And also then, if there is an objection, then the court will set it for an evidentiary. All right, anything further from the plaintiff?
No, Your Honor, thank
Anything
you.
further from defense?
No, Your Honor, thank you.
Okay, have a great day. Oh, you know what? I'm gonna see you both Wednesday for a settlement conference in
Yes, sir.
chambers in person.
Your Honor, if I just may politely remind the court, I have a prior obligation, and so I'm going to do everything I can to be there on time, but I will keep your office apprised of my travel as soon as I'm able to leave my hearing in Saginaw.
Oh, that's right. We did talk about that, and you're gonna let us know when you've hit the road.
Yes, Your Honor.
All right, we'll see you Wednesday.
Thank you, Your Honor.
This ruling sends a clear and powerful message. Courts take the preservation of evidence very seriously, particularly when public accusations, reputational damage, and financial consequences are involved. The judge did more than approve an adverse jury instruction. She also awarded attorney fees, openly criticized the defendant's behavior, and made it clear that this pattern of conduct would not be accepted. For the upcoming damages trial, this decision changes the landscape entirely. The jury will be instructed that they may assume the missing evidence would have been harmful to the defendants, which places them at a major disadvantage. This case now serves as a strong example of how ignoring litigation responsibilities can create serious consequences. If you found this case as surprising as we did, be sure to like the video, share your thoughts in the comments, and subscribe for more fascinating courtroom breakdowns. We'll continue watching how this case develops, and you won't want to miss what comes next.